Hello everybody, welcome to today's live. So what I'd like to do is talk today first about criminal waivers. Now, I've got lots of videos over the years on criminal waivers, but I thought I'd concentrate a little bit on this live about how you prepare one. Okay, it's one thing saying, you need a criminal waiver, and it's another thing actually preparing it and winning. Okay, it's a whole other thing. So I'll get through that first, and then afterwards, of course, I will answer all your questions. I will let you ask whatever you want in regards to immigration. If it doesn't regard immigration, then I don't know I can answer it. And I'll just scroll through once I'm done and let you know about all that, okay? So let me just recap what a criminal waiver is. So somebody wants to come in the U.S., and it's either as an immigrant or a non-immigrant, okay? Or they might be here already, on whatever visa. They might be on an H-1B visa. They might be ready to adjust status, whatever it is. But because they have some criminal history, they cannot adjust status or they cannot get the waiver. Okay, or sorry, they can't get the visa. So the bottom line is that the immigration law allows you in various circumstances to do a criminal waiver. And what does that mean? Well, it basically means, okay, I want to apply for whatever it is I'm applying for, and I know I can't get in because I committed some crime in the past, even if it was 20 years ago. So what can I do in order to be able to get in? And the criminal waiver says they understand that, they know that you did something bad in the past, and they're basically, you're trying to convince immigration to forget about it and to let you in. Okay, that's the bottom line. That's what it comes down to. So the question is, how do you prepare a criminal waiver so that there's a better chance of success? Okay, and every case is different. Okay, I have clients who come in and they go, I need a criminal waiver. Can you prepare it by tomorrow? Okay, type thing. I'm exaggerating a little bit, but that happens a lot, believe it or not. So I have to let people know that number one, there's no, template exactly for a criminal waiver, and that every case is different, and that it needs to be prepared in such a manner that convinces the officer to say yes. Okay, you have to go into, the proceedings or wherever you're going to submit the waiver, and there's all kinds of places you'll submit the waiver. I can tell you, immigration law, where you submit things is much more difficult than many other areas of law because there's a myriad of different places, but minus that. So wherever it's going to be submitted, you have to understand first things first. When they get the waiver and the officer or the judge or whoever's adjudicating it, their first inclination is to say no. Okay, you just walk in the door thinking that. They're going to say no, okay? So what you have to do is you have to convince the person who's adjudicating your waiver to say yes. Okay, that's the bottom line. That is the job of a criminal waiver. Okay, I committed a crime, but I want you to say yes to the waiver to let me in. That's the bottom line. So how do you do that? Well, first, you can't discount the importance of a waiver, of the criminal waiver. That is the door that has to open for you to get in. It is almost more important than the underlying visa or the underlying green card, because you may easily qualify, for example, for a marriage petition. You might have been married for 4 years, known the person, your spouse, for 12 years, have 13 kids, whatever it is. So the underlying petition might be easy. Okay, you might have a O1 visa where you can show your extraordinary ability, alien, and you got 22 years experience as a mechanical engineer, whatever it is. So the key is you have to understand that, first of all, the waiver, if you need one, is the most important part, because it is the door that has to open for you to get in. If they could easily or not easily, whatever, approve the green card or the visa, but if you're inadmissible, you're not coming in or you're not getting it approved. Okay? So bottom line, you have to get the waiver approved to get the door open to come into immigration, okay, to get what you want. So don't discount the importance of the waiver. Don't think that, all you have to do is say, I'm sorry, it was 20 years ago, I was dumb and stupid, I haven't done anything since, so therefore, let me in. Okay, don't think it's that easy. A waiver is a discretionary decision, okay? The officer, the judge, who's ever looking at it, they can review it and they can say, well, nah, I don't think so. You haven't convinced me. Adios. Okay? They say no. Okay, so you have to take it step by step. You have to be coherent in how you present the case. So what do? So I'm going to tell you how my office does it, and then, you can prepare accordingly or have someone professional do it for you. So, of course, we prepare the attorney cover letter. Obviously, you have to have an attorney cover letter. So the first things first is there's a statement of facts, okay? Now, you can't be in a position where you misrepresent what happened, okay? That's going to get you in a big tub of trouble, okay? So there's a way of minimizing the bad stuff, which is the crime. Okay, you have a crime. There's a way of minimizing that and then maximizing the bad stuff. So, when I'm doing the cover letter, there's a statement of facts. And you don't necessarily have to go into a lot of detail about the crime, okay? Although sometimes you might, okay? It depends on the situation. So let's say you're inadmissible because you have a charge of battery, a sentence of 4 months, okay? So first of all, you have to attach you have to make it easy for them to verify what the history is. Don't play games. Don't have them wonder. Don't start off by saying, I didn't really do it, okay? That's baloney. Don't do that, okay? Because then what you're doing is you're just discounting the fact you have a crime. And you have a crime, okay? If you need a criminal waiver, you have a crime. So first, just get in there, attach the documents. Don't attach the whole criminal file. That would be silly, okay? Attach the docket sheet or the abstract of judgment. Show that you have the crime, okay? And then show you what sentence you have. So get it out of the way at the beginning. I have, 20 years ago, I got convicted of battery. And when I say I'm talking about the, person doing the waiver, not me. I wasn't convicted. Okay, just to make clear. So you say, I was convicted of battery. I got a sentence of 4 months. In 1998, attached as Exhibit A are the docket sheet and the abstract of judgment and, the sentencing showing I completed it. Okay, so you get that out of the way. Okay, so number one, that's on the bad side of the scale, okay? So then what do? All right, so the statement of facts, again, just to get who's ever adjudicating it up to speed. Then you talk about how, you had probation for 3 years and you completed the probation. You can talk about how, you did a expungement or, got a reduced or whatever because you successfully completed the probation. You can show, hopefully, rehabilitation, how you went to various anger management classes and, you attended 6 months, you attended everything, you showed that, you learned, you committed the assault, and, you can also show history that you've never done any crime again. Now, obviously, every case is different. Some people have more than one crime, and some people have to waive more than one crime. And that's why it is very important that the facts are, elucidated in this manner to make it clear. Okay, so you get the facts out of the way. You show what the crime was. You show what rehabilitation occurred, and you show where you are now. Okay. I also like to show in the statement of facts what U.S. citizen and lawful permanent resident relatives you have, because immediate family members, because you want to start building up the sympathy of the judge or the adjudicator. You don't want, I mean, you understand when you walk in the door, you're a stranger and they're going to say no. Okay. They are inclined to say no. So you say, okay, I'm married to a lawful permanent resident. I have 3 kids that are, 14, 12, and 8. And they were born here and so forth. So you start building up the story. Okay. You might see if there's any medical issues with the kids or with the spouse. You might say, one of my children, is in, 4th grade and has ADHD and is in therapy and taking this and that. And let's say that the waiver has to show, which many of them do, the criminal waiver included, hardship to, for example, a U.S. citizen, spouse, or parent. Well, let's say you can't really directly show the hardship to the spouse or the parent. What do you do? I always call bootstrap the hardship to the spouse. So if a child has some medical issue or some psychological issue, or even if there's nothing, but there's like 3 children and the waiver's not granted, well, you can certainly show that if the waiver's not granted and you can't help, raise that child type thing because you're not going to get the green card or come in, you can show all the hardship that's going to accumulate to your spouse, because now your spouse has to do everything themselves, okay? So you bootstrap the hardship. Now, what else can you do to show hardship to the spouse? So the qualifying relative is an important part of a criminal waiver, okay? Don't discount that. Don't just say something like, I have a U.S. citizen, spouse, and he or she is going to suffer if I don't get this, okay? That doesn't say anything. That doesn't mean anything, okay? You have to show how they're going to suffer. Break it down economically, financially, emotionally, medically. Show what happens if you have to go to your home country and wait there, or you can't come in, and that your husband and your wife, whatever, have to stay here. Show what's going to happen if your kids have to go live with you in a foreign country, okay? Look at the State Department reports. Show the dangers that exist in that country and how it might affect you. Show what's going to happen and all that. So that all is a lot how I break it down. So, usually a very detailed declaration by the qualifying relative would be attached to the waiver. And also, I find it helpful to go to a psychologist, to have a qualifying relative go to a psychologist that will evaluate the hardship of this person if their spouse, for example, is not allowed to get the waiver and to come in. You see where I'm going with this, right? This is much more involved than just saying, oh, my hardships, my spouse is going to suffer, please let me in. So the psychological report, which I usually attach, assuming I can get one, which I usually do, shows, all of the bad stuff that's going to happen psychologically to the spouse if they're left alone. That shows all the hardship that's going to attach if the kids are left without their parent, things like that. And normally it's a very detailed multi-page analysis by the psychologist, and that, of course, is attached as a waiver, okay? So that's part of the exhibit. Now, the other part, once all that's done, once you can show all that hardship, is you want to have some contrition, okay? You want to show that you're sorry. And here's where you get into a little bit of the facts of what happened, okay? I mean, for example, you not to minimize the assault. I mean, I would never do that. But you might say, well, you were young, you were aggressive, you were stupid, And let's say that you got in a fight at the a brawl and a fight at a bar. Okay, so you might say it was just something dumb that happened. I got there, and you had some silly argument with someone about politics, and things got out of control. Just to admit kind of what happened, and so forth, and that you want to show that you've been rehabilitated. Okay, so you show you've gone to the classes, that you haven't had any further crimes, that you've raised a family, and then you want to show good moral character. So you want to say, maybe if you have acted as a volunteer, show you have a good job, get job reference letters, get a letter from your boss. Okay, all this stuff assists and helps you to prepare the criminal waiver. So if there's anything that I have conveyed here, is that waivers are not easy, okay? They take a lot of preparation, and they're super individualized to the particular client, okay, or to the particular person. And they are important, okay? So that, in a nutshell, is how you prepare a criminal waiver and everything that you need to put in there. All right. Obviously, if you don't want to do this yourself or you can't do it, give my office a call. All right. Well, how is everybody today? That was my initial spiel. Let me back up through all of the comments here. I like to start at the beginning, or I'll never get it straight. So give me a minute. Let me just back up here. Okay, here we go. I'm at the beginning. Here we go. Okay, so I'm going to go through, see what questions I have, answer them one by one, and then we'll go from there. Okay, how did everybody enjoy the debate last night? If you're a Democrat, it was a great night. Okay, let's see. Just a minute. Takes a while to scroll through everything here. Just a minute. Okay, we're getting there. Everybody have patience, right? Yeah? Go ahead and ask your questions now, because I'm scrolling. Okay, just a minute. Okay, got it. Our first question here. Can you change your date of birth after multiple years later? Okay. You have to understand, if you do that, immigration's going to think, the officials are going to think you're committing fraud. Okay, they think you're lying in the first place. Just like, I mean, you might think I have a negative view, but it's just a reality. Okay, you have to walk in the door and think everything you say they're going to think is a lie, and everything you do, they're going to think you're trying to commit fraud. So everything has to be properly proven. So the first advice I'm given here is, no, you can't do that. Okay, you can't just change your birth. Now let's say there's issues here with your birth certificate. Okay, let's say that it's actually put as a wrong date from the beginning, and let's say that you maybe you were born and didn't go to the hospital, and the hospital put one date on the birth certificate, and the person who delivered you put another day. Okay, so then you do have to change it to the correct one, because let's say that you have these two different birth certificates, and every time you submit something under immigration, you have to go through this big deal. So then in that case, the answer is yes, but it has to be done. It has to be done with a very detailed explanation why. Okay, you can't just change it and go, well, my birth certificate says I was born in 1964, and now I'm changing it to 1969. Okay, first thing they're going to think is maybe you're trying to get an immigration visa as a younger person so that the visa number becomes current. Okay, all kinds of stuff. So the answer is probably no, but there is possibilities of doing it if it's valid, with a very detailed explanation of why. Okay, so that's that. Let me scroll down. We'll get to the next one. Just a minute. Alrighty. Second. By the way, if you qualify for the Biden administrative order, while it has been enjoined by a federal judge in Texas as far as adjudicating them, it has not been enjoined as far as filing them. So you want to be prepared to have them ready to rock and roll and file if it needs to be done. Okay? All right, just a minute. Okay. Well, I have from Rosie Ramos. It says, "Good morning, y'all. I have a question." Well, I don't have your question. I need to know what your question is. So, write you may have written it below, and I'll get to it. But I need to know what your question is to answer you. Oh, here it is. All right, good for you. All right, my son was denied for a misdemeanor trying to file VAWA. He does have a child with medical. Okay, and I assume you mean medical conditions. Okay. Well, we have two different things in this question. Okay, I mean DACA is one thing, and VAWA is a completely different thing. Okay, I mean, he can certainly be denied DACA because he has a misdemeanor, and I'd need to know what the misdemeanor is. But if he qualifies for VAWA, well, then that's a way better way to go, because DACA is temporary, and you know how they fight it all the time as to when it'll end and what can be allowed, and even the new Biden administrative order on immigration that just came out, it only, for DACA recipients, it extends easier ways to get the work permit, but it doesn't by itself lead to the green card. So I'm going to pass that part of your question and move right on to VAWA. Now, VAWA is a battered spouse petition, okay? So if he's filing for a battered spouse petition, that means he was either emotionally abused or was physically abused, or both, by his wife, okay? Or if he's married to a man, by his husband, okay, whatever. And that all needs to be shown, okay? So the money here is on the VAWA. I mean, don't worry about DACA right now. Get the VAWA. So if he has a misdemeanor, then again, I would have to look and see what it is, but it's very likely that a criminal waiver would be available under VAWA. So again, this goes exactly to what I was talking about, in that, he may have a super good VAWA case, but unless the waiver gets approved, he's not getting in. But when he submits the VAWA, he needs to submit a waiver with the VAWA, okay? And needs to explain, like I've, did at the beginning, everything that goes into the criminal waiver, okay? And especially because VAWA, the burden of proof is lower than many other types of immigration petitions, which is great, right? It's great because whereas petition A, you need to prove this, and it needs to be at this level to win. With VAWA, it's a bit less, because, the way the law looks at it is, they're a victim, and they don't want to make them work as hard to get it as others. That doesn't mean it's not, hard to get it, but I'm saying it's less than others. So do the VAWA, submit the waiver with it, and then, hopefully he'll be in, okay? And again, having a child with a medical problem, while that may not be a direct, see again, this is where you bootstrap it. That might not be a direct hardship to the child, because normally with criminal waivers of this type, he can't show direct hardship to the child. That doesn't mean that they can't bootstrap it to your son. So if your son is taking care of the child, and the fact that you're telling me this would indicate that the spouse of your son has left, okay, is gone, which means that he has custody of the child. That by itself is a good thing with the waiver, to show that he's doing what he has to do to raise the child, and that if he doesn't get the waiver, then that child, whatever the medical condition is, may have to go back to his home country, and that may be a country where they don't have near the resources the U.S. does, okay? So there's all kinds of ways of showing the hardship to your son, okay, both physical and mental, from having to deal with whatever the conditions are of the child. Okay, does that make sense? Alrighty. Okay, and I know you said, can we file? I mean, this is your son. I mean, I assume he's over 21 and married and so forth. Okay, so he has to take care of his business. But by doing that, and if it ultimately goes through, then he can help you, the parent. Okay, but he has to help himself first. Okay. All right, so I think it just skipped by a bunch of stuff. Let me just make sure here. Okay, so more or less, oh, wait a minute. Okay, so this one here, am I able to fix my husband's immigration status even if I have a pending federal court case? Okay, so I'm assuming that you are a U.S. citizen and whatever your federal court case is, the answer is it depends what the federal court case is. Now, let me just tell you. Let me just use an example. You're a U.S. citizen. You're petitioning your husband, and the criminal waivers and all that. That never applies to the U.S. citizen. That always applies to the foreign national. But there are incidences where the criminal history of the U.S. citizen do affect being able to petition, for example, your husband's immigration status. And let me tell you what those are. Okay, those are. I mean, it was brought by Adam Walsh. Okay, there's a whole kinds of legislation that happened because essentially his daughter essentially ended up being killed by U.S. citizen because it was sexual abuse. And sorry, it might have not been killed, but it was sexual abuse committed by a U.S. citizen. So if your pending federal court case has anything at all to do with sexual abuse, then you can still fix your husband's status, but you're going to need to file what's called a Walsh waiver, which, since we're talking about waivers, that is and I mean the hardest waiver to get approved in immigration law. Okay, I've done over 3 decades tons of different kinds of waivers. Criminal waivers, medical waivers, public charge waivers, non-immigrant waivers, and we're talking about, fraud and misrepresentation waivers and so forth. Without doubt, Walsh waiver is the hardest. So I need to know if your husband qualifies anyways, but assuming he does, if your federal court case has nothing to do with sexual abuse, then, which is likely because it's in federal court, unless there was any type of abuse done on federal property, then that would most likely be in state court. So if your federal court case is whatever, let's say you have some tax evasion issues or whatever it is, that has no effect whatsoever on petitioning your husband. Okay, so get down to business and petition him. It won't affect him. Now, if you're a lawful permanent resident and you have a federal court case for something which could end up putting you in removal proceedings and having your green card revoked, then yes, definitely it's going to affect your husband. So I need to know if you're a U.S. citizen or a lawful permanent resident, because as a lawful permanent resident, you definitely will need immigration assistance to make sure you don't plead to anything in federal court that's going to negatively affect or make, if you happen to have to be put into removal proceedings, in a much worse position. Okay, does that make sense? All right, let me make sure I didn't skip any other questions here. Can you help vacate a felony in Texas? Okay, so this is what I do. Immigration law is federal law, right? Which means I can practice immigration law anywhere in the U.S., and I do. I have clients all over. I mean, I've traveled all over. But a felony in Texas is a state law, okay? Which means more or less a criminal attorney in your state should be the one to vacate it. Now, I can tell you that the criminal attorneys in wherever state, we'll talk Texas, is probably very good at criminal law, but they probably don't know a whole heck of a lot about immigration law. And I've had people in the past who go directly to criminal attorneys, get something vacated, which is great, except they don't do it properly under immigration law. And what happens is then they try to reopen the doors in immigration law, and they end up getting it denied because the vacating order wasn't properly done under immigration law. Okay, if that makes sense. So what I do if the crime's not if it's in California, and I'm licensed obviously in California, then I do my firm does the criminal relief directly. If it's anywhere else, then what happens is you hire the criminal attorney, and then you also hire my firm, and then my firm communicates directly with the criminal attorney, and essentially we both prepare and review what the criminal attorney has done and what needs to be done, and then we review everything that they're going to do to submit to the criminal court and say, well, no, you can't do this because that'll fall under this in that case under immigration law and it won't be effective. Okay, so we work together in order to maintain and protect you so that if it does get vacated, that it'll actually help. Because why get something vacated for immigration purposes if it doesn't do what it's supposed to do, right? You've wasted time and money. You have a vacated judgment, and then if you need to turn around and get it vacated properly, it's already vacated, making your case even more difficult. Okay, so that's that. Just a minute, I'm going backwards here. Okay, there we go. So I don't think I've skipped any. Let me see if there's any more questions at the bottom here. 1 second as I scroll up. Okay. 1 second. We have a lot of I have a lot of scrolling to do. Someday maybe I'll find a more efficient way to do this. Okay, so I think we're all good. All right, well, that is going to do it for the live today. So everybody send me your love and give me some hearts so I got a decent number there. And I want all of you to have a good day. Let me just answer this last question here. My probation ended in 2021. When can I apply for the N400? Okay, well, first of all, technically, if you qualify, you can apply to become naturalized, the day after your probation completes. Now, I need to know what your crime is in order to know if you should naturalize, because believe it or not, there's people that go in, they naturalize, and not only do they get the naturalization denied, they end up being put in removal proceedings. Okay, I see that you say you have DUI. Okay, so that's a decent one to be able to naturalize, and it also depends what state you're from. But generally speaking, with a DUI, number one, there's ways of making arguments for naturalization, even with the DUI, even with not completing probation, and even with still being on probation. However, given I said that, it's always easier to be off probation. So the answer is, assuming you qualify, you can file right away, but you have to be very careful how you do it and how you present it. There's people who don't present it properly and they end up getting charged with fraud, okay? Because they think, for example, they have a DUI and they got it expunged, so therefore they no longer have a crime, so they don't have to list it on the naturalization. And of course, the officer at naturalization looks at that and says, well, you just committed fraud because you didn't tell me you had a DUI. Okay, so if it's done properly, you can, and you qualify, you can go ahead and you can file now. Okay, you don't have to wait. When I do it as an attorney, I show, number one, why, and depending what jurisdiction you're in, why a DUI doesn't make you ineligible for naturalization in the first place. But secondly, even if the officer disagrees and you're done with probation, how you've been rehabilitated and so forth. So there's all kinds of good arguments that could be made. Okay, I think you're waiting for the 5 years because you think you fall under that, but that's not true. That doesn't apply to your particular case. Okay, so again, you can. Everybody can who needs more info can give me a call, or go on my multiple different platforms to see what it takes to get a consultation, and we go from there. All right. Well, I hope everybody enjoyed this. You're welcome. Hope everybody enjoyed the live. Until next time, everybody have a good day.